It says Furman boy, Jonna boy, November 5th, urine drug screen is negative. So my son was negative for all drugs. My son was negative for all drugs. My son was negative for all drugs. You can see my name right here, Jonna Furman. Caseworker is Madeline Morrow. And it says that she spoke with Dr. Tan, the child's main doctor. The doctors explained to the mother that her drug use caused a placental abruption and severe brain damage. My son was negative for all drugs. They wrote out a paper to terminate my rights, and these are the grounds. It says, upon arrival to the hospital, the mother refused a cesarean section for several hours, which could have prevented oxygen loss and other brain damage to the child. The hospital eventually performed the procedure against the mother's request in order to attempt to save the child's life. The child and mother also tested positive for opiates and marijuana at the birth of the child. My son was negative for all drugs. I found this where it says patient is now refusing a C-section from the time of 4:10 to 4:16 a.m. I realized that instead of several hours like they said, that I only refused a C-section for 6 minutes. I did go to Shands Hospital and I paid $1 for a copy for these few pages, and it shows that they took me in to operate on my arm at 3:17 a.m. This is my name, Jonna Furman. This is the pre-op evaluation. The medication they gave me was morphine. I looked up morphine and I found out that morphine was an opiate. Dr. Bruce J. McIntosh explains during trial that an emergency C-section operation to deliver the baby must be done as quickly as possible to get it out where it can breathe or be breathed for, since it's not getting oxygen from the mother. And he says if the treatment is delayed, then depending on the severity of the abruption, the baby is likely to die or suffer permanent brain injury due to lack of oxygen. Did any reports reviewed by you indicate whether there was a delay in the treatment? Yes, the records did indicate that. What was the cause of the delay that the records indicate? The records indicate from the time of 4:10 to 4:16 a.m., a period of 6 minutes, the mother refused to have a C-section done. If you remember on the grounds, it says the mother refused a cesarean section for several hours. I found this paper 3 days before trial showing that I only refused one from 4:10 to 4:16 through their own discovery. So the day of trial, instead of them saying I denied one for several hours, they changed their story to 6 minutes. He says the records indicate that from the time of 4:10 to 4:16, a period of 6 minutes, the mother refused to have a C-section done. So you can see they changed their story to terminate my rights. Did you review a drug on the mother? I did. The results indicated that the mother was presumptively positive for marijuana, opiates, and oxycodone. But right here, it never said anything about oxycodone. It just said opiates and marijuana. So they added oxycodone because of the fact that I found this paper showing that they did indeed put the morphine in me. So they made it so that I couldn't fight them in court. He says if she was given medication for pain, would that also have the ability to show up positive on a drug test? He says no, because marijuana and oxycodone are not medication that are used to control pain in a hospital setting. This is my name right here, Jonna Furman. This is Shands, Jacksonville. This is oxycodone, and this is all of the times that they gave it to me. This is more times that they gave it to me. 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 More. That's it. All oxycodone. Oxycodone. This is from the judge's final order terminating my right. He says the judge says the mother goes on to claim that the opiates must have been administered by medical personnel and has no clear answer regarding the presence of oxycodone. The records, together with common sense, indicate that no medical personnel would administer these type of narcotics to a woman who was 8+ months pregnant. While at the hospital, it was determined that a result of damage to the placenta, an emergency C-section should have been performed in order to save the unborn child. For reasons still unexplained, the mother dwelled on this decision for 6 minutes before consenting to a C-section. Not surprisingly, the child was born with profound and severe brain damage. So basically, he terminated my rights because of what this doctor said. This is an affidavit by Stephen N. Pine, medical doctor, state of California, and it says that if you look on his affidavit, it's Jonna Furman. It says, I further state, here he says, it is my medical opinion and reasonable grounds exist for Ms. Jonna Furman to initiate medical negligence claim against the physicians involved in the delivery of this infant. Later on, when I found out proof against this, They still went into court and changed their story to get my rights terminated, so I couldn't come back later and sue them. Because once your rights are terminated, you are no longer the mother. You cannot sue them. After that happened, I got pregnant again 3 days before my son passed away. And I had another child after all of this happened, after they terminated my rights. I got all of the proof, all of the medical records, and a new law came out saying that I can never show any of this proof, and they will take every child I ever have, even though I can prove that fraud was committed against me and my children.